Okay, thank you, Byron. And with the new license law, there are new forms that are going to be required, and there's really two tracks for these forms. They're either the forms that we as the association are going to create for our members, but they're also the forms that the law specifically states that the Real Estate Commission has to create for the all licensees. So kind of go through these briefly. These have been approved at the last Real Estate Commission meeting last week, and they're available on our website in draft form. So you can see here, this is our legal update page. If you have not been there yet, it's just screaltors.org/legal update. On the top are the draft forms that are, just for SCR members, and the bottom are the draft forms for LLR. So the first one we'll go over is the agency disclosure. The first thing to note is that they've changed that because through the license law, the new form is now called Agency Relationships in South Carolina Real Estate. You'll also notice the easiest way to remember come January 1st, if you're using the correct agency disclosure form, is now they have made it a vertical form as opposed to horizontal, and it's kind of gotten away from the brochure look, and it's now just more linear. You can see on the first page that they have added transaction brokerage under you are the customer of the brokerage. They took out the language in the form that it used to say questions you should ask your agent or ask the person given there. We kind of pleaded with them that we think that's kind of getting close to that line of providing legal advice, and so they needed to remove that, so they did. And we brought this to our forms committee, and one of the big things our forms committee asked was to say, hey, can you make sure that you put on here that this is not a contract? And they have added in there that they have added that this will not be a contract, so they did that for us. The next form that we will go over is that this is the form that the license law said that it had to be created, and they said that the Real Estate Commission had to be the ones who promulgated this form. So this is a very simple form. The only time to use this is if you are representing a seller and the seller does not want to counter the buyer whatsoever, they just want to outright deny the offer, then you will need to sign this and essentially fill out that the offer from whichever buyer for what price was received on this date was presented to the seller and it was rejected. I know we at SCR have our form 312, which is used as for multiple offers or solicitation of a new offer. That is a different form. That is if you're doing a counteroffer. This form should only be used if there's an outright rejection with no counter wanted whatsoever. The only other form, just so you're aware of it in case you see it out there, the Real Estate Commission was not required by license law to promulgate a transaction broker agreement. However, the chair thought, hey, only half the licensees in the state are realtor members. We know the Realtor Association is going to create their own form, but we need something for the membership as a whole. So they created this as a template. They have said, brokerages are free to tinker with it, edit it as they may need to. And of course, like I said, we will have our own transaction broker agreements. If you're listening to this webinar, you don't need to worry about using this form yourself, but we did want you to be aware in case you see it out there that this wasn't something that people just printed off of Google, that is a form created by the Real Estate Commission. And other than that, I guess the only other big and like I said, if you have any update or any questions on these forms or any suggestions, feel free to let us know. We do attend, I do attend all the Real Estate Commission meetings, and I'm happy if there's any significant concerns that you guys have to bring them up during the public comments portion of those meetings. And with that, I will hand it back to Byron.
Thanks, Austin. And LLR, like Austin, he monitors it. Rod Atkins, the administrator over there, last week I was down in Charleston for a license law presentation by Rod Atkinson, Real Estate Commission administrator, and he is trying to do a webinar with us in November. We're looking at a tentative date, November 17. I want to remind you to check your local boards for classes. I know several instructors are teaching license law, and that SCR will be having some classes and traveling around the state. Stay tuned for those dates as they shore up and get hard dates for those. But be aware that local boards and LLR and SCR are training folks on the forms. So, like Austin said, he goes to the Real Estate Commission meetings. You can see on the Real Estate Commission website, you can pull up the minutes. Their September 7th notice minutes are on the website where they talked about education. They're talking about having an education starting after the next renewal cycle. And it talks about their forms committee led by Commissioner David Lockwood that Austin just went over the information on that on. So. And what I've been saying as we go around is kind of new year, new laws, new forms. So Happy New Year 2017. The new license law will take effect. New year, new laws. Here's the law. You can see it's over 50 pages long. We'll be going through this here in a second. But this is the new license law that passed, with no nay votes. All the legislators voted in favor of it after, I think, like 6 years of work by realtors and lobbyist team. A new year, new law. And new forms, Austin talked about those. The new forms, Austin went over the LLR forms. Here's the forms committee chaired by Peggy Gainey of Columbia. Have come up with 6 new forms, the license law, the compensation, and this is all at SC Realtors legal update. This has been in our weekly newsletter, but if you go to this page, these are all draft forms. These draft forms are also being loaded on zip forms. You don't use these yet until 2017. They've got a draft watermark, but you can see here Austin's shored up the short policy. This is good for sole practitioners or handing out to auditors. This is the your written policy. The long one, Austin's waiting on some answers from the commissioners, and he's shortened that back up from about 150 pages down to 40. And one of those webinars that we talked about earlier on SC Realtors YouTube channel, we go through this license law update checklist that brokers can use to go through and train their agents. You can see it's pretty long. License law is long, so this form is long. You go through and check boxes. You train your agents on each item with the license law, and then the agent can sign it down at the bottom that they've read it. It's got all our contact information. There's our emails there. Phone number 803-772-5206, and then the websites where you can read these forms and you can read the new law at scstatehouse.gov. And thanks to Diana Brothers who helped us get this form, this four-way cross-check the broker trust account. You can see the draft watermark. Basically, you do this when you do your monthly reconciliations. Write down the files that have associated trust funds in them. You pick the date because it's a snapshot in time. You have the total amount of your trust funds, your trust account balance, your general ledger balance, your total sub-account ledger balance, and then it says are 1, 2, 3, and 4 equal? Yes, you're good to go. No, maybe you explain it. Hey, I've got $100 of my own money in there to handle bank fees. So that's the four-way cross-check form. And then back to the list. Thanks, Diana Brothers, for that. And then kind of a new form. Austin went over some new forms. This is a new form that you'll be using. He talked about the offer rejection form. This is the form where you've got multiple clients, especially buyer clients. Say you've got buyer client 1, buyer client 2 at your brokerage, and they're both trying to buy the same house. You would handle this form. It basically says, hey, in our buyer agency agreements and listing agency agreements, I've always said, hey, buyers and sellers, we may be representing other people pursuing similar properties or trying to sell similar properties. We protect your confidential information. Basically, confidential information is the willingness or ability of a buyer to pay more than the offered price, and the willingness, ability of the seller to accept less than the offered price. Any confidential negotiation strategy of a party that's not disclosed in the offer or counteroffer. The motivation of the buyer to buy, the motivation of the seller to sell. So that's a new form. That's in license law. It says you have to use this form. The Real Estate Commission did not create one, so your Realtor Forms Committee, chaired by Peggy Gainey, developed one. And then this is the one that Austin was talking about. This is kind of the form we had, thanks to Commissioner Candace Pratt, REMAX, down in Somerville, helped us develop this a few years ago. This is one where you could reject and set, reject multiple offers and then set up a highest and best. Like Austin said, there's a government form that you'll use to reject offers. This is for more setting up the highest and best. And then we're updating the compensation agreement to cover trade. Basically, all our forms will have little additions for transactional brokerage that we're going to be talking about. So kind of the key thing to remember, new year, new laws, new forms. So that's kind of the thing I've been saying when I go around. Some of the highlights, we're going to go through some highlights, and then we'll just go plow through the license law. So if you're watching this and you want to come back later and go through and fast forward or rewind, you can do that on the SC Realtors YouTube channel. But we're going to kind of hit the highlights for you folks that want to get on to lunch now and maybe watch later. But the first one is education. Our surveys around the state said, hey, we need better education. There's some bad real estate licensees out here that don't know what they're doing. They're going to get the broker sued. They're going to get buyer client or seller client financially harmed or even sued. So that is to increase education. All our surveys that said, hey, increase education, increase the quality of education, increase the choices of education. So you got your wish. The legislators voted to increase education from 8 hours every 2 years to 10 hours every 2 years. So an incremental change. We'll keep fighting for more hours. Increase the options that you've got, the subjects you can take, the delivery methods, distant learning, internet learning. Your realtor designation classes count for CE. So the CE is increased, and like I said, those minutes reflected after the next renewal cycle, they will go to those. The CE waiver, we recommend you always take CE, but the CE waiver will be 25 years of licensure, but you'll still be required to take a 4-hour state law course. So and also for brokers in charge, there'll be a 4-hour broker in charge class. So for brokers in charge that are just trying to do the minimum of continuing ed, you're going to be basically dictated. You'll have your 4-hour state law core course, you'll have your 4-hour broker course, so that's 8 hours. And then the National Association of Realtors is going to require you to get your 2.5 hours of ethics training every 2 years instead of every 4 years. As a reminder, make sure you get your ethics done before New Year's Eve as well. So if you're broker in charge, you've already got 10.5 hours set for you. You got your 4-hour core course, your 4-hour broker course, your 2.5 hours ethics course. So that's 10.5 hours. Anything else that you'd want to take would be additional. There's no carryover CE. There'll be no more provisional licenses starting next year. You'll go ahead for pre-licensing, which will count for CE. You'll get your 90 hours all up front. So education. The other thing that license law handles is teams. We saw the World Series last night, Cubs, Indians. The teams will be legalized and regulated for the first time in license law. So the teams are defined as 2 individuals. They have to be under a supervision of 1 broker in charge, and the broker in charge must supervise the team, regulates how teams can advertise. The teams have to make sure that they are not fooling the public into believing the team is the brokerage. So make sure your brokerage name and is all of your advertising and your communications. The Real Estate Commission has targeted some teams and even individual licensees that, in the commissioner's point of view, are basically masquerading or camouflaging themselves as kind of a standalone real estate company or standalone brokerage. So remember that you're under a brokerage, you need to advertise that company name. The idea is if a consumer has a problem, they know how to get in touch with your supervising broker in charge and work some sort of arrangement out or who to file a complaint against. So do not masquerade as a brokerage. Make sure your brokerage is in all your communications and advertising in a reasonable way. And then we talked about related to transaction brokerage. Everybody gets all freaked out about transaction brokerage. But remember is customer service. So here's kind of the pop quiz of the test. You can write this down at your desk. You don't have to share it with anybody, but usually realtors don't do so well on this pop quiz. So under current law, until January, say your brokerage does not have the listing, and you've got a buyer customer. You've given them the agency disclosure brochure. Put them in your car. You're going around town showing them properties, and they decide they want to buy a house that's listed with another brokerage. What is the deadline that you must have a buyer agency agreement with this buyer? So this lady in this photograph, she's got a buyer customer. He wants to buy this house. Her brokerage does not have the listing. When is the deadline for her to have a buyer agency agreement signed with this gentleman? So go ahead and think of that in your mind or write it on a scrap of paper. So this is our pop quiz. And I'll give the answer here in 3, 2, 1. The answer is by the time of the offer. So a lot of times when I go around the state, agents don't realize that. So they would be in license law violation. So the transactional broker customer level service cures that. Starting in 2017, you can take a customer all the way through closing. So the deadline will be closing. So some good things about transactional brokerage, customer level service all the way through closing. It gives you one more option, one more tool in your toolkit. Over the years, we've had a handful of buyers that refused to sign a buyer agency agreement. You would not be able to take those folks to close. They would not sign a buyer agency agreement. You could try to refer them somewhere or hand them off to the listing brokerage. But this would give you an option in 2017. You can say, hey, I can help you. I can be your transaction brokerage. I'll treat you as a customer all the way through closing, and we'll be good to go. Transaction brokerage is that one more option alongside your options right now are single agency representing the buyer, representing the seller, sub-agency representing the buyer, the seller, and single agency via their the listing brokerage or the buyer agency brokerage. Your dual agency is out there and your designated agency is out there. So transactional brokerage will be alongside single agency, sub-agency, dual agency, and designated agency. Other benefits to transactional brokerage. There's a case out in California that may, eventually spread across the country where judges say you can no longer do dual agency, you can no longer do designated agency under the legal idea that it's impossible to wear two hats at once. You can't represent the buyer and the seller in the same transaction. If that happens, transactional brokerage is kind of our lifeboat. This would be a way for brokerages to have listings and help buyers if dual agency and designated agency may go away. It also helps folks in commercial transactions. A lot of times sophisticated commercial sellers and buyers will refuse to sign an agency agreement. So transactional brokerage would allow you to serve those customers and suit their needs. And it reduces risk. So under agency, you've got a duty of, like Diana Brothers teaches the old CART acronym: obedience, loyalty, disclosure, confidentiality, accounting, reasonable care, and diligence. Customer level service, you can strike at least two of those, obedience and loyalty. So that's two less ways that a trial lawyer could try to sue you if something were to go wrong. So it reduces risk to treat people as a customer instead of a client. And also over the years, we've had some arbitration, some commission disputes where somebody was procuring cause, but say their buyer agency agreement had expired or they never had a buyer agency agreement, or the buyer tried to terminate the buyer agency agreement. There was some unfair arbitrations where these people had been procuring cause, they were the reason the sale came through, but because transaction brokerage was illegal in South Carolina at the time, they were unable to prevail at arbitration. So transactional brokerage will allow more fairness in arbitration commission disputes. I think a lot of people, some of the people are operating on some rumors out there thinking like, oh, I'm just going to have realtors, or real estate agents just claim to the commission because under transactional brokerage. That's not going to be the case. The hearing panel in an arbitration, they're going to look at what this person claiming the money did, were they the procuring cause, the reason of the chain of events from start to finish of a closing before they can become procuring cause and get the compensation. A hearing panel would never award, say I just email a listing to somebody and a year from now they end up buying the property and I've never done anything other than that. For that person that emailed it, that licensee to email it, then to claim to be procuring cause under transactional brokerage, that's kind of a rumor that's out there that's false. That would never be allowed for somebody to get the commission that way. So we got transactional brokerage. So we got teams, and then some kind of practical changes for the agents. Right now, when you get cash or certified funds, you got to turn those over to your broker. Right now, even checks, you've got a little bit of time to get your broker. In 2017, that goes away. You have to get these checks to your broker the following business day. So agents can't carry checks around in their car, in the briefcase, in their purse, in their pockets. They have to get that check to the broker in charge the following business day. And the broker in charge is still under the same old deadlines, the 48 hours after ratification to deposit checks. But this is to help the brokers. There was some agents that had lost some checks, so this will help speed up that process. For the agents, though, This will be a big change for the agents. The agents will need to know, hey, I've got to get that check to my broker the following business day. And then the broker is under the deadlines. And you can always deposit stuff early, but 48 hours after ratification, the broker would have the deadline to deposit that. And then for agents, that are investors, say I'm an agent and I'm selling properties, buying properties, flipping properties. A couple things. Right now, you've got underlined capital letters on page 1 of the contract. In 2017, if I'm an agent owner selling the house, this picture right here would be a license law violation because it does not say agent owner. So in advertising, you have to say you're an agent owner and disclose that. So you want to disclose agent owner up front as much and as often as possible in all your marketing and advertising. If I'm running it through my brokerage, obviously I'd have to have my brokerage name on the sign, but I'm a realtor and I flip real estate. I'm flipping this house for sale by owner. I do not have to have my brokerage name in the sign, but in 2016, the sign's legal. 2017, the sign is illegal because I do not have agent owner in the sign. So that's a big change there. And kind of going back to the money that we were talking about, if I am an investor or realtor, I'm flipping houses, I either have to run the trust funds through a lawyer's trust fund or through my brokerage, or I have to have my own personal trust account for other people's money. So the Real Estate Commission will take your license for shenanigans with earnest money, trust account money, other people's money. So be very careful. If you have any questions, contact the hotline. So we talked about that. And then it's getting close to Halloween. So this would be an example of a sign. It says zombie free. So that's kind of the Halloween joke. But you can see here it's got the brokerage name up there. For teams and for individual licensees, you want to make sure your brokerage is front and center there. All right, then before we get into law, and Mike, Ralston, we got any questions that we need to address real quick?
Okay, one person asked, when will the 10 hours of CE take effect?
It's an excellent question. So we'll go to the minutes of the Real Estate Commission. This is the minutes. I think this is this 21st of September was the one. Let's look here. You can see the licensees. There's 46,000 licensees in South Carolina. Over half are realtors. Of course, realtors do about 90% of the business. So here under unfinished business, it says 2017 renewal of continuing education requirements continued from the September 7th Real Estate Commission meeting. The South Carolina Real Estate License Law has been amended effective January 1st, 2017 to require the addition of continuing education hours for renewal of a license. Since the Commission is currently in the middle of a renewal cycle, the question was discussed whether or not this change would affect licensees that are currently in the middle of their renewal period renewing in June 2017. About half the licensees renew every year, so this affects probably half of you. You need to make sure you look at your pocket cards and make sure when your license is up for renewal. And then the motion, Commissioner David Lockwood, who also chaired the Forms Task Force, made a motion to postpone implementation of the additional continuing education to July 1, 2017. Mr. Wayne Poplin, the at-large commissioner, seconded the motion and it carried unanimously. And then you see a motion. Mr. Andy Lee, Commissioner out of Seneca, made the motion to require all South Carolina real estate course instructors attend an instructor development workshop provided by the Commission for the purpose of reviewing the new real estate license law. Mr. Stackhouse seconded the motion, which carried unanimously. LLR made those motions. SCR's position is new license law takes effect 2017. So if you want to be super safe, go ahead and get those extra hours done. It's only 2 extra hours, going up from 8 to 10 hours. The new license law takes effect January 1, 2017. But that's the Real Estate Commissioner's position, and then the SR position is, hey, license law, like Steve Spurrier used to say, it is what it is. So the license law goes into effect January 1st. Comply with the license law is always the safe answer. But that's the Real Estate Commission's answers. All right, so we talk about new license law, and this is where I'm just going to start going through license law. It'll be very boring, but you've hit the highlights, education, teams, customer service, get the checks to your broker the following business day. If you're an agent owner, you've got to advertise agent owner, and you've got to have your own trust account if you're not running it through a law firm trust account or a brokerage trust account. But we're just going to, start going through the license laws. Questions come up, we can address those, and we'll kind of just start at the beginning. You can see here the sponsors were Senator Alexander Davis, went into the Senate and when the session started. And the new session won't start again until January 2017. The legislative group has been meeting over the summer and as late as this week to try to come up with some, what they call a cleanup bill. This is a long bill. Everybody knew that there would probably be some unintended consequences, some typos, some advisory opinions that maybe warrant some language improvements, like English is an imprecise language. So the SCR legislative group has met with some teams, met with the CMLS recently, talking about this cleanup bill and going back in to try to clean up some unintended consequences. But that obviously won't happen until January, and then the process starts anew, so January through June. The new license law goes in effect January 1st, so it is what it is. It is the license law, so the safe answer is always comply with what we're getting ready to go through here. And it's a big rewrite. There's a lot of information to go through. And we'll just kind of start here. You kind of see it took basically from January till May to get it through the State House. No opposition on any of the votes. And this was about a 6-year process based on rallies and annual conference meetings and legislative committee meetings and focus groups and surveys and grassroots effort from you out there responding to calls to action. So a long process, but it culminated last year. So here we go. All right, so here it is. We're basically in Title 40, Chapter 57, and then we're just going to kind of go through this and start at the beginning. So it talks about, the first is definitions. So we've got a bunch of definitions. It talks about what an agent is, what an associated, there's the where my pointer is, agent, talks about what an agent is, what an associated licensee. Associated licensees are working under the supervision or a broker in charge, a property manager in charge, who is responsible for them and trains them. The broker is has got his broker's license and then can take the license exam and become a broker in charge. And it talks about what you can do. So you can, these are the things you can do for money in South Carolina. And it talks about you can attempt or negotiate the listing, sale, purchase, exchange, lease, or other disposition of real estate or the improvements to real estate, auctions or offers to auction real estate in accordance with the auction statute. For a fee or valuable consideration, you can solicit a referral. You can offer services as a real estate consultant, counsel, or transaction manager, offer to act as a sub-agent, a real estate brokerage firm representing a client in real estate transaction, or advertise or otherwise represent the public of doing any of the above. So if you don't have a broker in charge license and you're not supervised by a broker in charge, you can't do any of these for money. So it's for all you licensees out here, this is why you work for a broker in charge. And then you say, what is a broker in charge? It's defined in the next one. That's the person that's responsible for all the associated licensees and has the liability for the trust account. And then we talk about single agency. You got buyer agency is where you're representing a buyer in the capacity as defined. And the big change in 2017 is clients and customers. Clients is somebody that you've entered a written agreement establishing an agency relationship with a brokerage firm through its broker in charge, manager in charge, or an associate licensee. This is your classic buyer agency agreement, listing agency agreement. Everybody else is a customer. You can represent them in customer status under transaction brokerage all the way to closing now. Commission, we've talked about those folks. There's 10 commissioners. A lot of them are realtors headed up by the chair, David Krigler out of Greenville. And then conversion is something something you never want to do. You can lose your license for this. This is when you don't do what you're supposed to with a trust account, use somebody else's money. You can go to jail for it. You can lose your license. So anytime you hear trust account, escrow account, make sure your ears perk up and you pay attention and you're reconciling your accounts as broker in charge and you're being very careful with other people's money with the checks. There's some scams that are trying to attack your trust account. So be careful for those. We've got some webinars and scams on the SC Realtors YouTube channel. So customer, this is something like now you can handle a customer. If you got the listing, you can take a customer buyer all the way through closing if your brokerage has the listing. If your brokerage does not have the listing, then you've got to have a buyer agency agreement before you submit the offer. In January, you'll be able to take a customer all the way through closing. It's a big change in 2017. And then we talked about the commission. Designated agency, this is the deal where it's created in 2005. It's an agency where within the brokerage, 2 agents are firewalled off and designated, hence the name designated agency. The broker in charge designates 1 agent to represent the buyer, designates another agent to represent the seller, and then you act like you're separate brokerages to some extent. You hide confidential information, you lock down your files, you lock down your computers, you lock down your conversations, you lock down faxes and inboxes, so that confidential information, which is the willingness or ability to pay more or less for the purchase price, negotiating strategy, your motivation to buy and sell, because that would harm your negotiation position. If somebody knows, hey, somebody is getting a divorce, or somebody's getting a new job, or somebody's got to start school right away, it would give them an advantage in negotiation. So that information has to be locked down within the group inside the brokerage between these designated agents. Dual agent is the other way that you can handle the buyer and seller clients both within the same firm. And designated agency, everybody but those 2 designated agents are dual agents, including the broker. So the designated agents can go talk to the broker in charge and get advice, but everybody else is a dual agent, which basically means you do not have a duty to relay confidential information. So designated agency has some risk because you've got to firewall off information. Dual agency, a little bit safer than designated agency, but both are high risk. We talked about a case out in California where lawyers are attacking, say it's impossible to be a dual agent or a designated agent. It's impossible to represent the seller, client, and the buyer-client transaction. If that spreads across the country in the next few years, transactional brokerage that goes into effect in 2017 may be the lifeboat. But right now, both are single agency, designated agency, dual agency are legal, and in a few months we'll have transactional brokerage all the way through closing. Everybody knows what email is. Everybody knows what licensee is. Kind of a new change in the license law. Limited function referral office has always been a realtor means to lower your fees. Say you were a retired realtor and you had a social circle, you could do referrals. Problem is you had to have an active license to do referrals. So when you called the real estate commission would say, yeah, you can do sales. And then your realtor association would say, no, you can't do sales. So to make it clear, when you call the real estate commission, if you're in a limited function referral office, you have to keep an active license, pay your fees, do your 10 hours of CE, but you can only do referrals. Kind of a big lawyer change. It's probably it's a big lawyer change, but the average realtor on the street, material adverse fact, material fact, not a big difference, but legally there is a big difference. Material fact, basically, in common law says that you have to disclose anything that could affect somebody's decision making, which pretty much anything would fit into that definition. So we've tightened that definition up. In 2017, you only disclose, note the middle name we've added in are adverse. So material adverse facts. This carves down, reduce your risk from the common law, and it's defined as anything that affects the value of the property significantly and adversely, anything that affects the structure, integrity, and improvements, or as a health risk, or indication that somebody does not intend to meet their obligations under the contract. So you got SVH in contracts. So structure, value, health risk, and then contractual, somebody's going to welch on the contract. Those are material adverse facts that you must disclose. You want to try to make the seller disclose them if you can, or the buyer disclose them if they can. But at the end of the day, you have a duty to disclose those. Ministerial acts, that's basically filling the forms. You've got standard forms through the Real Estate Association, SC Realtors, and some of the local boards have some forms. Means you can fill in the blanks. If your attorney has drafted up forms or approved forms, you can fill in the blanks because you're not using your discretion or judgment. You're just acting as a scrivener, filling in the blanks. It's kind of a ministerial act. Office is your location where your broker in charge is located and is licensed to conduct real estate business. We talked about a personal trust account. This is for those agents that are flipping houses and they're not running trust funds. Say somebody puts a deposit on the house or they're renting a house from you and you're not using your brokerage trust account or the lawyer trust account, you've got to get your own personal trust account to handle other people's money. Property manager, somebody that, this is kind of analogous to when we went over the brokerage, basically negotiates sale and improvements of real estate, lists to provide a service for the rental of real estate, advertises as renting properties. Just like a broker in charge is a property manager in charge, broker in charge license is a property manager in charge. A broker in charge can do property management. A property manager in charge can only do property management, not sales. So. Defines real estate, a land, buildings, other pertinence, including all interest in land, whether corporal, incorporeal, freehold, non-freehold, whether or not the real estate is within or within outside the boundaries of the state. Real estate brokerage means the aspect of real estate business for property management, sale, exchange, lease, purchase, and lease. The real estate brokerage firm means the real estate company engaged in the business of real estate. Real estate transactions are the sale, purchase, exchange, or lease of real estate. And then, a lot of times we use slang agents, but really they're associated licensees, they're salesmen. So it basically says what a salesperson, gender neutral in the 2017 law. You meet the education requirements for CE and pre and post licensing, which will just be a pre-license in 2017. Passes the exam and engages in any activity up there, the broker activities that we went through. Seller agency is a form of agency where the real estate brokerage firm represents the seller in agency capacity. Sub-agent is an agent of an agent. An associated licensee is a sub-agent of the real estate brokerage firm, and the broker is an agent of the buyer, seller, landlord, or tenant. Substantive contact, this is what Austin was talking about with the agency relationships in South Carolina. That used to be the old brochure. They kind of made it easier to print out on an 8.5 by 11. It just talks about substantive contact, discussion and dialogue between the consumer and the associated licensee moves from casual introductory talk to meaningful conversation regarding their real estate business. Basically, hand these documents out, agency relationships in real estate out like candy. I've seen some agents that even put them as a part of their email signature, a link. You would email these out, keep a stack of them in your car and hand them out like candy, like trick or treat. Team means two or more associated licensees, and so the first time teams are legal. Prior to 2017, there is no team language in the license law, and it talks about advertising in your license name. So for the first time, teams are legalized and regulated. So a team is two or more. So obviously it's just me. I can't be a team. That would give a false impression to the public that there's more people working for them than just me. So a team has to be two or more associated licensees working together as a single unit within an office established by the commission and supervised by a broker in charge. So a team has to be within the supervision of one broker in charge with one office. So that's how they've defined teams. Same office, same broker in charge, not crossing brokers in charge or offices. And the Real Estate Commission recognizes that real estate is mobile now, that people have mobile phones, with Wi-Fi. You're able to conduct business at people's houses, at Starbucks. But if you're regularly using an office, you need to register that with LLR and get a broker in charge to supervise that physical structure. Even home offices are allowed. It talks about what a trust account is. It's designated, it has the word escrow in it. Established, maintained by a broker in charge. Talked about trust funds, received other people's money. Basically, you're handling other people's money. Be careful with it. You can lose your license. You can even go to jail for not handling it correctly. So transaction broker, this is a huge addition to license law. So this is a big change here. Transaction brokerage means a real estate brokerage firm that provides customer service to a buyer, seller, or both in a real estate transaction. A transaction broker may be a single agent of a party in transaction to the other party, customer service and facility transaction without representing either party. So it talks about the Real Estate Commission. Austin monitors that. You can go sit in on those as well. You just go to their website. You can see what the meetings are. A lot of them are realtors that are serving on that. There's 2 non-real estate related folks serving on that, but you can go anytime. We publish their orders on people that have broken license law in our weekly update. If you scroll down to the bottom of the weekly update, you can go and you can look up And you can see who's violated license law. That can help you with sales meetings. Hey, don't do this. Lessons learned from other folks. So. And it talks about the commissions, how they get elected, how they get their seats. A couple new commissioners are taking seats. Commissioner John Reinhardt of Rock Hill has recently joined the commission. And then it talks about fees, and I'm trying to save a little bit of time by going through here. It talks about non-resident. As long as you're doing your CE in your state and you're non-resident, you can have 2 licenses. Say you live in North Carolina, you got a North Carolina license, you do your CE in North Carolina, that can count for your South Carolina. If you live in South Carolina, you've got to take the South Carolina CE and follow the South Carolina rules. That's something Rod Atkins has been talking about. Talks about what a broker in charge shall do. Property manager in charge, broker in charge. You got to supervise your employees and associated licensees to ensure compliance. Review and approve all forms, listing agreements, agency agreements, offers, contracts, purchases, lease, contract addendum, basically any form, and maintain adequate, reasonable, and regular contact with associated licensees. So you can supervise them. You've got to maintain contact with your associated licensees and supervise them. You're responsible for them for license law violations and realtor ethics violations. So you want to, brokers in charge can supervise multiple offices, multiple companies, multiple associated licensees, but at the same time, don't spread yourself so thin that you can't reasonably supervise these folks. Otherwise, you may be facing lawsuits or license law complaints or ethics complaints yourself. And you have to be available to the public to resolve complaints and disputes that may occur. You've got to establish and maintain a written office policy. Austin's working on his office policy. You can download it from our website right now. The short form policy is good for sole practitioners. It's good for audits. The long form is good for communicating with your associated licensees. Make sure that all your associated licensees get their CE done and pay their fees and keep their real estate active license. Otherwise, you're unlicensed and you can't practice real estate. And then be responsible for a trust count. We talked about the 4-way cross-check form that's on the draft forms that Diner Brothers helped us create. Notify the commission of any changes. That address talks about associated licensee may not receive compensation from an activity requiring a real estate license from an entity or person other than one for which the license is issued. Associated licensee may form a business entity. A lot of people do that for taxes and liability reasons, and the broker in charge can pay into that corporation as long as the principals all have an active license. The broker in charge have to have a specific office location accessible to the public, investigators, inspectors from reasonable business hours. The property manager, here's what we talk about, you can have different locations, and as long as you can supervise those. And licensee may not conduct real estate business under any other name or address but the one which his license is issued. In the event, and then there's some stuff if the broker in charge gets incapacitated, how they can appoint somebody in the office to run it. And you've got to keep files for 5 years of any leases, contract to sale, listing, contract to buyer agency agreement, transaction brokerage, option contracts, property management agreements, residential property disclosure forms. You can keep those as electronic as long as you can print them out for the investigators. And if you're advertising real estate, you've got to have a listing agreement with the property owner. And when advertising, marketing real estate owned in whole or part by another person, you must identify the full name of the real estate brokerage firm. So make sure your brokerage firm is reasonably apparent in all your advertising. And if you're using Twitter and you're tweeting something or some sort of short form, you can include a link back so that the recipient can always find the homepage of the brokerage firm and know who to file a complaint against, how to get in touch with the broker in charge to resolve complaints. The real estate brokerage firm operates under a trade or franchise name. The identity of the franchisee or holder of the trade name must be clearly revealed. Here's the thing we talked about, the big change for agents that flip houses or rent houses. A licensee shall clearly reveal license status in a personal transaction involving the purchase, sale, exchange, rental, lease, or auction of real estate at first substantive contact with the consumer. And note, in advertising and marketing in any medium. So make sure that you put agent, owner if you're selling property. And in our forms, on page 1, you got the underlined bold capital letters that says, agent, licensee is a principal in the transaction, is a party of the transaction. Trust funds received in a licensee's personal rental transaction must be deposited in the licensee's personal trust account, may not be deposited in the real estate brokerage firm unless the real property is managed, listed by the brokerage, or using a lawyer's trust account. So if you're, agent, owner, selling property, go ahead and set up a trust account or run it through your brokerage or get a law firm that's going to handle the trust account for you. But it's other people's money, so you have to protect it in a trust fund. And it says no licensee, either directly or indirectly, may buy for his own account or for a corporation or any other business which holds interest for a close relative real estate listed with him, or real estate which should not approach without making his true position known in writing. This is a big deal for associated licensees to buy brokerage listings or associated licensee to sell to brokerage clients. Call the hotline if that's coming up. You've got to do a lot of disclosures. You've got to bend over backwards to make sure you don't get sued or have an ethics complaint. This is at a minimum that you disclose it, but there's a whole range of things you can do to try to protect yourself in those situations. And with regard to offers to purchase real estate, licensee shall, upon receipt, prepare all offers in writing and promptly present them to the seller, obtain written acceptance offer, promptly deliver true and executed copies to all parties, ensure that all terms and conditions of the transaction are included in the offer to purchase, and ensure changes or modifications made during negotiations are in writing and initialed and dated by both parties. So this is a big deal. Make sure you get initials and dated on all changes. Make sure everything's in writing. This is an ethics and license law issue. So everything's in writing, so there's no arguments. Don't try to do things verbally. Don't use text messages. Use the standard forms. Use your zip forms digital ink to get electronic signatures, electronic initials. Keep everything clean and keep you out of trouble. A licensee shall promptly complete an agency agreement, transactional agreement. Austin talked about transaction broker agreement, offer and counteroffer. A listing or buyer agent's representative agreement must be in writing and set forth the material terms of the parties' agency relationship, including but not limited to a description of the agency's duties or services to be performed for the client, including but not limited to an explanation of office policy regarding dual and designated agency, amount of compensation, how and when the compensation is earned, how it be divided with cooperating brokers, the amount of retainer fees collected from performance, duration of agency relationship, signatures. Listing agreement or buyer agency agreement has a termination date, must state if it's exclusive agency or exclusive right to represent. Must specify an exception and variation of amount of commission and circumstances. It would be variable rate commission. A copy of the listing must be given, or the buyer agency agreement to the parties upon signing. The buyer's representation agreement must provide adequate description of the property type, interest to the buyer, price range for the property. Listing agreement must have a legal description or identify the property. And these are all in your standard forms. We've got basically 4 forms, 2 for sellers, 2 for buyers. Exclusive agency, that would be for a seller that's going to try to sell their property on their own as well. And then buyer agency, we've got an exclusive right to buy and an exclusive agency for buyers. If there are no clients in the transaction, real estate brokerage firm acting as a transaction broker shall complete a compensation to be signed by the agent, the compensating party, and must be have who's responsible for payment. The broker in charge shall assure that associated licensees prepare all offers and counteroffers in writing, have them dated and signed by the offers, promptly present them to the offeree's representatives. You want to make sure that you put things in writing, you initial and date any changes, make sure all the terms are in there, and give copies when things are signed. You can do that electronically or by paper. If offer is rejected without counter, an offer rejection form promulgated by the commission signed by the licensee affirming the presentation of the officer. Offer must be presented to the offeror by the licensee with the agent buyer. So this is the one Austin was talking about. This is the offer rejection form. An offer and counter offer may be communicated by use of a fax. It's basically saying you can use zip forms, faxes, email to send contracts. You don't have to do it all by paper. And again, if you're thinking about buying some property listed with your brokerage, at a minimum, you've got to make your position clearly known in writing. Call the hotline. There's a lot of things you can do to help make sure you don't get ethics violations or license law violations or lawsuits. It's high risk to set up to buy for agents for associated licensees to buy listings It's high risk for the agent and the brokerage and licensee for agent owner to sell to buyer clients in the brokerage. And in order to claim a fee, a separate written agreement signed by the seller client must acknowledge the purchaser or licensee. Is all, again, call the hotline if you're doing any of these things. It's high risk behavior. Real estate brokerage firm shall manage residential properties. So again, kind of similar things to the sales. Your agreement of what you're going to do has to be in writing. You have to give copies. So you have to identify the property, who are the parties, the method of compensation. You can't have an automatic renewal clause unless you put in underlying capital letters at page 1 that compensation for a future lease renewal by tenants must contain underlying capital letters at page 1. In terms and conditions of the tenant rental or lease agreements, the management agreement may not bind under a listing agreement. If you're going to sell the property that you're managing, you do have to have a separate listing agreement. For all types of real estate transactions, including leases and sales, the unlicensed employee of the owner. So this is what unlicensed folks can and cannot do. So here we got these things here. Discuss, negotiate or explain a contract, listing agreement, buyer agency agreement. So basically you can't use your discretion as an unlicensed person to discuss or negotiate agreements. You can't, number 2, vary or deviate from the rental price or other terms. Again, unlicensed folks cannot use discretion. You need to have a real estate license to be using judgment and discretion because you need training and education. Approve applications. So you can't approve applications of leasing, if it's just a standard lease, but you can't approve them because that takes judgment. You can't indicate to the public that you're in a position of authority and you're managing things. And this is a big one, number 5. You cannot conduct or host an open house as an unlicensed person. You cannot show property unless you have a real estate license, except units in a multifamily. It's your classic apartment building where you've got unlicensed people working in the front unit. And they've got pre-printed leases and they're just taking people, letting them into the apartments. And again, number 7, you cannot answer questions regarding listings and title and financing, because those are all judgment issues for real estate licensees and lawyers and lenders to discuss. Number 8, you cannot be paid solely as an unlicensed person on the basis of real estate activity. That includes a percentage of commission or amount based on listing and sales. So you got to have a license to be paid in that way. Number 9, you cannot negotiate or agree to compensate commission. Again, judgment, so you're not doing those activities. You cannot engage in activity requiring a real estate license. So that's what the unlicensed folks can do. And it says real estate licensees, you don't have to save those text messages or your instant messages. You do have to save those other voicemails. You do have to save, those contracts we talked about earlier in your broker files. And this is talking about earnest money when you take other people's money. You've got to have a trust account, and the trust account must be maintained by the broker in charge at a bank, and you must train your agents on how to handle the money. And you must do your monthly reconciliation, keep complete records because you're going to get audited at some point. You can keep electronic copies. You cannot commingle your money, except you can keep a small amount of money in there to handle bank fees or keep the account open when there's no trust account in there. And here's the big change in 2017. So trust funds received by licensee in connection with a real estate transaction have to be delivered to the broker in charge no later than the following business day. And it talks about a broker in charge, a property manager in charge who disperses trust funds contrary to the terms of the contract or fails to disperse trust funds not in dispute is considered to have demonstrated incompetence to act as a broker in charge, a property manager in charge. And this is once the agent gets the following business day, gets the money, the check to the broker. Here's the deadlines for the broker. So Roman numeral I, little I. Cash or certified funds must be deposited within 48 hours of receipt, excluding Saturday, Sunday, or bank holidays. And checks must be deposited within 48 hours after a lease or rental agreement is signed by the party of the transaction, including Saturday, Sunday, and bank holidays. Rent received by a licensee is directly employed by the owner or property manager must be basically put rent into a trust account.
Byron, the rules on the checks belong to all checks, not just cashier's checks, right?
Well, it says certified funds, so I think if you've got a cashier's fund, it's arguably certified funds, so then you're arguably under Roman numeral little I.
But not a normal check doesn't need to be there 24 hours next business day.
Yeah, so personal check. Now both of these, anything that the licensee gets following business day, you give that your broker charge. A huge change, big change. Anything that a licensee gets from a client or a customer has to be to the broker charge the following business day. So once they get it, then you're under these deadlines for the broker charge. So cash or certified funds deposited within 48 hours of receipt, including Saturday, Sunday, bank holidays. Checks must be deposited within 48 hours after a lease or rental agreement is signed. And there's mimic language for sales down here that we're going to see in a minute, excluding Saturday, Sunday, and bank holidays. Rent received by licensee is directly involved with the owner of rental property must be deposited in operating or similar account, but otherwise must be properly accounted for as in this section. So that's kind of your classic apartment, people that are working in an apartment, employees. And then talked about trust funds received by broker in charge or property manager in charge in connection with the real estate rental or lease, including but not limited, basically every kind of money. Security deposits, pet deposits, damage deposits, advance rent, all that's other people's money and must be put in the trust account until the lease or rental transaction is expired, is terminated, at which time the undisputed trust funds must be dispersed pursuant to the contract, which directs the broker in charge, property manager in charge to hold the money. Earned rental proceeds must be dispersed to the landlord within a reasonable time after clearance from the bank. And here we kind of have the mimic language for sales. So again, we'll reemphasize this stuff. So trust funds received by broker in charge in a sales or exchange transaction must be deposited in a separate trust fund account. Cash or certified funds deposited within 48 hours of receipt, excluding Saturdays, Sundays, and bank holidays. Checks must be deposited within 48 hours after written acceptance of an offer by the parties of the transaction, including Saturday and Sunday. So again, licensees, agents, associated licensees, you get anything, cash, certified funds, personal checks, you get those to your broker the following business day, and the broker has these deadlines. You can always deposit early, but these are on the back end deadlines. And then it talks about trust funds received by broker in charge in connection with the real estate sales or exchange transaction deposited in the real estate trust account shall remain in the trust account until consummation or termination of the transaction, at which time the funds are dispersed in accordance with the contract, which directs the broker in charge to hold the funds for a full accounting made to the parties. And I'm going to digress a little bit because we're working with the real estate commissioners to try to get an opinion on this. After the 2009 shooting of a broker in Fort Mill, over $1,000 of an interpleader that was continued, the Forms Committee put several contractual ways to get earnest money back to the buyer. You've got your due diligence, the buyer timely and properly terminates with a termination fee, they get the earnest money back. You've got financing contingency, the buyer tries to get the loan, doesn't get the loan, they get their money back. The appraisal contingency comes in low, seller won't reduce the price to that appraisal, the buyer gets their earnest money back. The Real Estate Commission the LLR investigators have taken an odd position that the association doesn't agree with. The investigators have said that contractual disbursement of earnest money is illegal in South Carolina. You can see in this license law clearly that you can disperse per the contract. Just this highlighted section shows that. But at any rate, until we get that clarified, they are the investigators. They are the persons that investigate you, or they are the persons that will write you up. So until we get this settled with the commissioners, the safe answer is you only disperse with a written release, a written disbursement agreement, a written mediation agreement to disperse the money, or a signed court order. So the safe answer is you kind of comply with the investigators for the time being until we get the commissioners to opine on this. Commissioners held a hearing on this last November and didn't opine, and we're working to get an answer to this. But the safe answer right now is get the release, Form 518, get the disbursement agreement 517 signed, get the mediation agreement dispersing money signed, or get a court order signed by a judge either through interplate or other means. So that is. And it talks about broker in charge, a property manager disperses trust funds from a designated trust account in the following circumstances considered to have properly fulfilled his duty. Upon rejection of an offer, upon withdrawal, an offer not yet accepted, or at the closing of the transaction, the Real Estate Commission has said you can send money over to the closing attorney out of your trust account, or the attorney can take money out of your commission equal to the earnest money, and then when you get back to your office post-closing, you can take the earnest money, account for it, move it out of trust and into your account. So it talks about if a dispute concerning the entitlement to and disposition of the trust fund arises between buyer and seller, and the dispute is not resolved by reasonable interpretation of the contract with the parties of the contract, you must hold it until you get a written agreement. This would be your release or your disbursement agreement or your mediation agreement, or you file an interplea or you get a court order or they mediate. So kind of the key words here is a dispute. So is there a dispute? So in the contract, it talks about 30 business days for the seller to raise a legal dispute. Because it talks about up here dispersing at termination, and say the dispute arises after you disperse the money, creates issues. And then it talks about reasonable interpretation of the contract by the parties. So I've not heard any of the parties raise any other reasonable interpretation to due diligence addendum, to the financing contingency, the appraisal contingency, the 30 business days. But at this time, until we get that resolved, go old school with earnest money. Get a release signed, get a disbursement signed, get a court order. Records required for this chapter, you have to keep them 5 years. You can use electronic storage. Broker in charge, have a trust account. They have to keep a record keeping system of that. It talks about the journals, talks about how you basically do your monthly reconciliation. We got the 4-way cross-check form that Diana Brothers helped us develop in those rough drafts. Trust funds received by broker in charge, property manager is drawing interest. That money belongs to the clients unless they agree otherwise, and in our forms you can have that checkbox where the client can allow the broker to keep that earnest money. It's here. Owners of trust fund have been informed of the right to ownership or relinquish right to ownership. That's in the standard forms of the checkbox. And this talks about who's not under license law. You've got or sell by owner people, attorneys acting within the scope of their duties in the legal representation of the client or owner, agencies, instrumentalities of the state and federal government, their employees, foresters, if the sale of land is incidental to the sale of timber, or court-appointed receivers and trustees while acting within the scope of their duties. All right, then we get into Article 3, real estate brokers, broker in charge, and salespersons. We've got, talks about how old you got to be, what kind of education you got to be, what kind of training you got to get. The big change for a salesperson's license in 2017 is this section. The pre and post education is all combined into pre-education. The same amount of education, 60 hours and 30 hours, so 90 hours will be on the front end. So if you've got anybody that wants to be grandfathered, they need to go ahead and get their stuff done for January 1st.
So how does it work if you were getting your provisional license in December?
Right, so the question is, what if I've got my provisional license in December? You're going to be basically grandfathered through, going through. But January 1st, the new law goes into effect, so if somebody wants to be provisional in January, too bad. Can't do it. But if they get it done between now and December, then Rod Atkins and the Real Estate Commission said there'll be a group of people that are kind of grandfathered through. But January 1, the new law takes effect. And it talks about for broker license, 150, you can use your, your 90 hours. Talks about taking the exam. A lot of these questions, questions on your license, you can call the hotline, but you're best off to get in touch with the Real Estate Commission and get it, who you're talking to, and if you can get it in writing from a Real Estate Commission employee, an LLR employee, that's the best answer for anything that has to do with your license, because they are the people that license it. The main thing is that your education, your CE is going up to 10 hours, and these instructors are going to be reporting the number of hours you take. So until 2017, we've been under an honor system, that honor system goes away. If they want to know exactly how many hours you've taken, if you tell a fib when you're renewing your license about saying you took the education, you did not, obviously that could be a license law violation, and you could be subject to a fine or suspension, probation, or even losing your license.
All right, we've gotten several questions about exactly what the breakdown of each hours is based on classification of licensure. Can you go through that again?
Sure. Right, to be eligible for a real estate broker in charge, salesperson applicant must be 21, be 18 for salesperson, have a physical address for investigations, maintain the contact information, keep the address, have a high school or a GED, high school diploma or GED, submit proof of education for the commission, submit to a criminal background check, so there is no credit check anymore, and pass the exam. So
see, we had a lot of people asking for brokers, kind of what ethics hours are required versus the broker class versus your core course. What the breakdown was.
Yeah, the question was about say I'm a broker in charge in 2017. I'm going to be taking the 4-hour, state law, basically the core course. I'm going to be taking the 4-hour broker in charge course, and you can take the other 2 hours if you wanted to off whatever you wanted to add up to 10. But NAR is going to be requiring everybody to take 2.5 hours of ethics education every 2 years. It was 4 years, so now it's 2 years. So if you're broker in charge, if you just want to take the minimum, it's going to be spelled out for you. As a broker in charge, you're going to be taking 4-hour core, the 4-hour broker in charge course, and the 2.5 hours of ethics for NAR. So that's going to be 10.5 hours right there. You're only required to take 10. So if you're going to take other courses, certainly encourage you to do so, but as a broker in charge, you're basically locked in the state law course, the broker in charge course, and then your ethics.
And the ethics is required by NAR, but not through the state.
Right. So I'm assuming, most people are reasonable. So if I got to take 2.5 hours of ethics, I might look for a provider that's giving me CE for that, so I can double dip, like Austin said. That 2.5 hours, if you just wanted to take the NAR course that's not CE, you could do that. But I think most people are going to be reasonable and say, look, I got to do the 2.5 hours of ethics anyway. I'm going to find a provider that's giving me 2.5 hours of ethics CE for license law. So I would probably, most realtors are going to be double dipping that. They're going to find a provider that says, hey, NAR 2.5 hours of ethics every 2 years. I also did the paperwork to get it qualified for CE. So you can kind of double dip that.
The broker course is not going to be available for 2017.
Right. In Austin, we had an instructor meeting this summer. The instructors, Diane Brothers said, look, there's 7,000 brokers in charge. There's a process to go through the real estate commission and get a course developed. So there will, unless some miracle happens, there will not be a broker in charge course developed by June of 2017, which probably factored in to the real estate commission making that motion we talked about where they'll start enforcing the renewal CE starting in June 2017. All right, and then for a salesperson, you got to get the 60 hours of classroom instructions, fundamental in real estate, 30 hours instruction in advanced real estate principles, and then 5 years for the application. You can have a law degree. For a broker license, you got to do 150 hours, which could include your 90 hours, or have a law degree. And as a condition of licensure, the applicant shall submit to an application at the test taker. You've got to pass the exam on the wrong score. You got 12, once you apply to take the examination, you got 12-month eligibility period to successfully complete all portions of the examination. The applicant fails to successfully complete the application may reapply. And if you pass the exam, you got to apply for licensure with 1 year, or you got to reapply and take the exam again. If you're denied licensure, you got to wait a time period. A lot of this I was skipping because I was assuming most people on the webinar already have their license, and like I said, you want to contact LLR about any kind of license questions. And then for a broker in charge, you've got to have an ownership interest in the company and actively engage in the operation and management of the company. Person holding an active broker or salesperson license have to be active and licensed under broker in charge. So you've got to have a broker in charge to practice real estate. You've got to be a broker in charge or work for a broker in charge. And if you change, You've got to notify your broker, and LLR is going to notify the broker, and you got to keep all your addresses up to date. And then for license renewal, 10 hours of CE, 4 hours of instruction and mandated topics. That's the state law core course. Broker in charge has to take 10 hours approved by the commission. 10 hours include 4 hours of instruction and mandated topics, kind of the state law core course. And then 4 hours continuing education and advanced real estate topics for the brokers in charge. That's a course that Austin was talking about is unlikely to be ready. This thing here, this advanced real estate topics for brokers in charge. License must be renewed biannually, coinciding with the education deadline, half the licensees and even years. So make sure you check your pocket card when you renew. Exempt from CE if you completed your pre and post, you're on inactive, you're non-resident, you live in North Carolina, you got a North Carolina license, you do your CE in North Carolina, you're good to go. And this is the change here. They took out the 65 years of age because say you got your license when you were 20, when you're 45, you'd have 25 years of licensure. If you're already grandfathered under the old law, you stay grandfathered going forward. So if you're coming up on it, do it in October, November, December, because January 1st, the new law changes and says that you got to have 25 years and you still got to take your 4-hour core course every year. And if you're a broker in charge, you got to take your 4-hour broker in charge course. So you can't carry forward, so do your 10 hours every 2 years. If you fail to complete, they're going to catch you because you got electronic reporting, and they'll put you on inactive status. If you're broker in charge, that means all your associated licensees are inactive. And this is here where it talks about the students, their hours are going to be transmitted electronically, so at the end of the honor system, they will catch you if you're fibbing on your CE. So take your CE as you need to. Pre-licensing and continuing ed course is eligible for distance learning certification by RELO or the IDECC qualifies. Commission shall qualify for continuing education credit certification programs of national real estate organizations such as NAR. And it talks about notwithstanding any other provisional law, the Commission shall qualify for continuing education credit courses that are related to real estate technology, professional development, and business ethics. So you got to get your 2.5 hours of ethics every 2 years for NAR. You're probably going to double dip and find a provider that's giving you CE for those ethics courses. A real estate brokerage firm that provides services through an agency agreement. This is the classic old car that Diana Brothers teaches. Duties of loyalty, obedience, disclosure, confidentiality, reasonable care, diligence, accounting, so forth. And relationships, you can do single agency for the seller, single agency for the buyer, which both of those wrap in sub-agency because you're representing the seller via the listing agency, sub-agency for the buyer through the buyer agent's broker. You got disclosed dual agency, you got designated agency, and you got the new one, transactional brokerage. So this allows you to take a customer all the way through closing. We talked about all the good things about that. That'll help a lot of people. Broker in charge will adopt a written policy. This is the one that Austin's been working on, the long one. He's whittled down to about 40 pages. He's waiting on a few more answers on some advisory opinions from the Real Estate Commission. The short one's on the website, good for sole proprietors and audits. And in the broker policy manual, Austin's has all these in the short form. It's got the policy regarding transaction brokerage, agents, transaction brokerage, compensation, scope of services provided to the real estate brokerage firm's clients, scope of services provided to the real estate brokerage's firm customers, that's customers of transaction brokerage. When and how an associated licensee shall explain and disclose their brokerage relationships with an interested parties to a potential transaction. That's basically your agency relationship brochure that's being replaced by that new form. When now an associated licensee shall explain the potential for a licensee to later act as a disclosed dual agent, designated agent, transaction brokerage. That's basically in your agency agreements as well. The real estate brokerage firm on compliance with state and federal fair housing laws. So keep in mind, disabled folks are under fair housing laws. That's one that realtors often accidentally cross, especially things like comfort animals. On reaching a written agreement to provide services for a seller of real estate, the seller's agent shall perform the terms of the written brokerage agreement made with the seller. promote the seller's interest by performing duties, seeking to set the price stated in the listing agreement, present all offers and counteroffers, disclose to the seller all material facts concerning the transaction that you know, advising the seller to obtain expert advice on matters that are outside your license. Your license is for marketing and selling real estate. Don't be an inspector, don't be a lawyer, don't be an appraiser. Let the client hire those folks. Accounting for money in the trust account, use reasonable skill and care. Watch webinars, read the information from your associations, keep up to speed, attend conferences, and know what you're doing out there when you're practicing real estate. Comply with this chapter, so you want to read this license law, read those forms that Austin talked about. Comply with all the laws, state, federal, and local. Preserve confidential information that might have a negative impact on your client's activity unless they give you permission to disclose it, the law requires you to disclose it, or you got to defend yourself against some sort of wrongful accusation, or information becomes public from a source other than the broker. If you do all that, you can't get sued. That's what God says. And it may alter, if you're acting as a seller's agent, you may offer alternative properties to buyers. A licensee acting as seller agent may list for sale competing properties. This thing that our agency agreements cover, and then we talked about that new form from SCR disclosure to your clients that, you may be representing buyer 1 and buyer 2 clients after the same property. You may represent seller 1 and seller 2 in the same neighborhood selling similar properties. On reaching a written agency agreement, provide brokerage services to a potential buyer or real estate. Buyer's agent shall perform the duties, promote the interest of the buyer, seek property as stated in the buyer agency agreement, present in timely manner all offers and counteroffers, disclosing material adverse facts that you know about, advising the client to hire a home inspector, for example, hire a lawyer, hire a surveyor, hire an appraiser. All that's in reform where you recommend those. Accounting for other people's money, keeping up with your profession, with education, so that you're exercising reasonable skill and care. Comply with laws, state, federal, local. Preserve confidential information unless the buyer says, okay, you can disclose it, or you're defending yourself in a hearing, or it's required by law, or it becomes public from a source other than the licensee. And then no cause of action may arise against the licensee for disclosing confidential information in accordance with that. And again, you're going to be offering properties maybe to other potential buyers. You may have 2 competing clients in the same transaction. You give written notice, that's that SCR form, the disclosure brokerage service to multiple buyers and sellers are involved in the same or similar real property. Licensee, you treat all parties honestly. You may not give them false or misleading information about the condition of the property. You're not obligated to discover latent defects. That's for inspectors. So don't lie to them, but you can always refuse to answer. You can always say, hey, that's a great question. Let me write it down. I'll get the answer for you. And you can't get sued for information in a home inspection, an engineer's report, a surveyor's report, a geologist's report, a CL 100, unless you know they're false. And you don't disclose that. And it says you're not liable providing false or misleading information that's provided by the licensee or client or customer you didn't know was false or incomplete. So always be the sources of information. Never be the source of information. Always say, look, you need to get an inspector to look at that. You need to get a contractor to look at that. You need to get a surveyor to look at that. You need to get a lawyer to look at that. Because your license is for marketing and selling properties. Nothing in this chapter limits the obligation of the buyer to inspect. So buyers need to inspect the property or hire experts to come out there and inspect the property. Private eyes, home inspectors, HVAC experts, plumbing experts, dam experts, flood insurance consultants, all these expert professionals, they can help the buyers. Let the buyer choose who to hire and who not to hire based on their pocketbook. All right, so we're talking about dual agency. Dual agency is when you've got your brokerage has the buyer client and the seller client. You're not in designated agency. It could be one individual licensee, or it could be the broker in charge has one of the clients or both of them, or a brokerage that doesn't feel comfortable doing designated agency. They can't firewall off information. brokerage policy might be we just do dual agency. So it talks about, in A, it talks about, their adverse interest. Buyer wants to buy low, seller wants to sell high. So they're adverse goals for those two people. Associated licensees may disclose information gained from one party to the other if the party is relevant to the transaction, except that the information concerns confidential information. And the magic word for confidential information is the willingness and ability of a seller to accept less than the price, the willingness and ability of the buyer to pay more than the offered price, confidential negotiation strategies, or the motivations for the parties. Parties can choose to consent to dual agency, or they may reject it. So the way it works is if you got the listing, you got a buyer client, you want to write an offer, you get the buyer to sign the dual agency agreement. You present that dual agency agreement to the seller has to sign it before they see the offer. And the clients have to read and understand the dual agency agreement and acknowledge the consent. So that's the dual agency agreement. A brokerage charge in one office may conduct business with a client of another office as a customer client without creating the dual agency if these are basically separate offices, separate office. And this is talking about designated agency. So designated agency is where there's an associated licensee working with the buyer, the associated licensee working with the seller. The broker in charge basically designates them and then firewalls off information. Everybody else in the office is a dual agent. And this is talking about the designated agency agreement. Just like the dual agency agreement, works the same way. You got the agent working with the buyer, I'm working with the seller client. Buyer wants to write an offer, they fill out the designated agency agreement. That gets presented to the seller to sign before they see the offer. And this talks about if you've got say you got a practicing broker in charge, then you're going to be in dual agency. Because remember, the broker in charge is available for counseling with the designated agents. Broker in charge is representing one of the parties. You can't do that. So if the broker in charge is a practicing broker in charge, rather than more of a managerial type, you're in dual agency all the time when you have the client, seller client, and buyer client. And here it's talking about when you designate two of your agents, you as broker in charge act as a dual agent. You're not required to complete a dual agency agreement, you just are, so are all your other associated licensees. And this talks about a designated agent can go in and talk to their broker in charge about their side of the transaction. Broker in charge is kind of an advisor to both sides, and they're in dual agency. If a buyer client or real estate brokerage firm wants to view and make an offer to purchase property owned by a seller client being represented by the same brokerage, you must act with as a dual agent unless you all right, then it talks about all the remaining affiliated licensees are dual agents. You don't have to fill out a dual agency agreement, they just are per the designated agency agreement. Talks about there's no imputation of knowledge or information between the broker in charge and the client. Designated agents may not disclose except to the designated agent's broker in charge or appropriate representative. This is basically saying that you firewall off the information. The designated agents keep the confidential information secreted. And this basically says the same thing. A licensee who represents one party of the transaction may provide assistance to other parties in the transaction by performing ministerial acts such as writing, conveying offers, providing information and aid concerning. This is basically how you have a customer. Say you got the seller client, you got the listing agreement. You can treat some buyers if they're not under buyer agency agreement as a customer. You can do that now. And you will in 2017 as well. A real estate brokerage may offer transaction brokerage to potential buyers and sellers. Transaction brokerage may be a single agent. A party in the transaction can be the other party customer service, and the transaction brokerage may facilitate two customers. So if you got the listing, you can be a transaction broker with the buyer. If you don't have the listing, you can be a transaction broker with a seller customer and a buyer customer. So 2017 is a big change. Transaction brokerage can take customers all the way through closing. And it talks about licensees operating as a transactional brokerage are required to disclose to buyers and sellers the role offering customer service include honesty and fair dealing, accounting for funds, using skill, care, and due diligence in the transaction, disclosing material adverse facts that affect the transaction or the value of the condition of the real property that not readily ascertainable. Properly presenting all offers and counteroffers. Limited confidentiality unless waived by party. Limited confidentiality prohibits disclosing the buyer's willingness to buy. So you're a transactional brokerage. You got a transaction broker buyer, a transaction broker seller. You're going to keep confidential information confidential. Prospective buyers and sellers that choose not to establish an agency relationship with a real estate brokerage firm and use their services are considered a customer. And these are things you can do for a customer. You can identify and show properties for sale or lease. You can provide real estate statistics and information. You provide pre-printed real estate forms and contracts. You can act as a scribe in the preparation of forms and contracts. You can provide a list of architects, engineers, surveyors, inspectors, lenders, insurance agents, attorneys, and other professionals. You can identify schools, shopping facilities, places of worship, and other similar facilities on behalf of the parties of a real estate transaction. Licensee offering services to a customer. These are things you can do for a customer. Timely present all offers back and forth. Account for money in the trust account. Provide a meaningful explanation of brokerage relationships. That's your agency relationships in real estate brochure. That's now going to be a form. Provide an explanation of the scope of services provided by the licensee. Be fair and honest. Provide accurate information in all dealings. Keep information confidential as requested in writing by the customer. And disclose known material facts regarding the property of the transaction. And it talks about the statute supersedes common law. So material adverse facts override material facts in common law. All right, then we get into team stuff. Some of this teams and the cleanup bill, some of the things. But teams are finally legal and regulated under the statutes. The broker in charge is responsible for supervising the team and all licensed members of the team. Broker in charge may not delegate supervisory responsibilities to the team leader. The team act as disclosed dual agents only with a prior written and informed consent of all parties addressed in the broker in charge written office policy. Teams must conduct all real estate activities from the commission established office under the supervision of broker in charge. The commission obviously recognizes its home offices. People transiently meet at Starbucks or Cracker Barrel, but if you're renting some sort of timeshare office or something like that, you probably want to go ahead and get that registered with LLR and get the broker registered as supervising that. Team advertising must contain the team name, full name of the real estate brokerage firm. So always, 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 teams and individuals, make sure your brokerage firm is displayed conspicuously so that no investigator will accuse you of camouflaging yourself as a brokerage. No team may imply that you're separate from the brokerage. Team names are regulated. The team and all team members must display and promote they are not directly connected to the broker on which the firm, but they are directly connected to the brokerage firm under which the team works, brokerage firm name. So basically, make sure your brokerage name is on all your advertising, your signage, to try to keep LLR from coming after you as a team. Commission can promulgate team regulations. Licensee shall provide at first practical opportunity to all potential buyers and sellers meaningful explanation of brokerage relationships, disclosure of broker relationship form described by the commission. That's that form Austin went over. And acknowledgement of receipt. So this is a big change. The new form that Austin went over has a signature blank like he talked about. It says it's not a contract. So if you have people that are scared to sign it, say, look, this is required of the real estate commission. It just says that I explained, single agency, dual agency, designated agency, sub-agency, transactional brokerages, my brokerage offers. And so I'm at the time of first substantive contact is presumed potential buyer or seller is to be a customer of the real estate brokers and the real estate brokerage firm will be acting as a transactional brokerage. So everybody's a customer, transaction brokers till they sign a buyer agency agreement or seller agency agreement, aka listing agreement. If first substantive contact occurs over the telephone or via email, you can send this electronically. You can email the acknowledgement or receipt of disclosure of broker relationships. This will be in zip form, so that means you can use zip forms digitally to get it to sign it. For all real estate transaction, no agency relationship between the buyer, seller, landlord, and real estate brokerage firm associated licensee exists unless the buyer, seller, landlord, tenant. No type of agency relationship may be assumed by oral. You have to have it in writing. The payment or promise, payment of compensation to real estate brokerage firm by seller, buyer, landlord, tenant does not determine whether an agency relationship has been created. You got to have that agency document. The brokerage relationship disclosure requirements do not apply if it's for rent, so you don't use the seller or the agency disclosure for rental properties, communication from the licensee, solicitation of business. Real estate broker and all associated licensees owe no obligation to a client following termination, expiration, completion, performance of an agency or agreement, or closing the real estate transaction, whichever occurs first, set the duties of accounting for money, keeping confidential information received in the course made confidential by instruction of the clients, with those caveats, permit disclosure, required by law to disclose. You've got to defend yourself in a hearing, or it becomes public from another source. And I'm kind of going to whiz through the property manager because I'm assuming most people are, 90% of people on this are probably in sales. It goes through kind of the same licensing stuff for a property manager. Again, any licensing questions, you want to go to the real estate commission. They're the ones that give you your license. You want to try to figure out who you're talking to on the phone. If you can get the questions answered in writing from the real estate commission, because you want it to come from them. They're the government. They're the ones that issue the licenses. The hotline, we can try to help you with it. At the end of the day, the only answers that really matter are what's coming out from the real estate commission, either Rod Atkinson, administrator, one of the commissioners, or an LLR employee. All right, how do you get in trouble in South Carolina? Like we talked about in all of our weekly emails, we report. Austin sits over there and monitors these things, and they publish. They have a hearing, defense and prosecutor. If they find you in violation of any of this stuff, we'll talk about some of the fines and suspensions, take your license kind of thing. But this is the laundry list of things you can get in trouble for. So it says, commission, in addition to the engine bill, that 40-1-110, the commission may deny issuance of a license from an applicant or make disciplinary action against a licensee who makes substantial misrepresentation on the application for a real estate license, which is your CE. Don't fail on your CE anymore or ever. Makes a substantial misrepresentation involving a real estate transaction. Makes false promises likely to influence, persuade, or induce. Pursues a continual or flagrant course of misrepresentation, or makes false or misleading promises through any medium of advertising otherwise. In the practice of real estate, demonstrates bad faith, dishonesty, untrustworthiness, or incompetency in a manner as to endanger the members of the public. Represents one real estate broker other than the broker in charge or property manager in charge for which they're licensed. Guarantees or authorizes or permits an associated license to guarantee future property profits from the resale of real estate. Makes a dual set of contracts, written or otherwise, by setting a sales price other than the actual price. Is convicted of violating federal and state fair housing laws, forgery, embezzlement, breach of trust, larceny, obtaining money by false pretense, extortion, fraud, conspiracy to fraud, being convicted of felony, sex-related felony, drug-related cases, felony real estate-related, felony financial, felony violent offense, or pleading guilty or nolo contendere to an offense in a court of competent jurisdiction in the state, another state, or federal court. Fails to report the commission in writing by certified mail within 10 days conviction of a crime listed above. Fails to, within a reasonable time, to account for or remit trust funds coming into possession. Be careful of other people's money. Pays a commission or compensation to an unlicensed person for activities requiring a license under this chapter, notwithstanding this section. A licensee may not pay or offer to pay a referral finder's fee to an unlicensed who is not party to the real estate transaction. Violates a provision of law related to the freedom of buyer to sell or choose an attorney, insurance agent, title insurance agent, or another service provider to facilitate the real estate transaction. Fails to disclose in accordance with the above the party or parties for which the licensee will be acting as an agent in the real estate transaction, if any. Receives compensation in real estate transaction directly resulting from real estate transaction more than one party, except with the full knowledge and consent and written disclosure to all parties. Represents more than one party in real estate transaction without the full written knowledge and consent of all parties. Acts as an undisclosed principal in a real estate transaction. Accepts deposit money which is to be delivered to licensee's principal in a real estate transaction without informing the payor and having the payor acknowledge in writing hold the money received by the licensee, issues a check in connection with real estate business, which is returned for insufficient funds or closed account, fails to disclose in accordance with the above a known material fact concerning a real estate transaction, violates a provision of this chapter regulation promulgated under this chapter, violates a rule of order of this commission, knowingly gives false information to an investigator or inspector, engages in a practice or takes action inconsistent with the agency relationship that other real estate licensees have established with their clients. Fails to make all records required to be maintained in this chapter. The commission for inspection and copying by the commission upon request of investigator. The commission fails to appear for an interview with the investigator of the commission without due cause. Fails to provide or provides false information upon direct inquiry by the investigator or inspector. Fails to promptly submit all offers and counteroffers in a real estate transaction. Fails to provide current contact information to the commission. Allows or creates an unreasonable delay in the closing of a transaction in a manner which causes the failure or termination of the transaction solely due to a dispute among participating licensees concerning the division of commission. All right, so they're going to notify you of the charges. It says an investigation must be conducted with their engine bill 40-1-180 performed by investigators who have completed the required amount of training. Talks about how they can do a restraining order. They have LRS to conduct their investigation in a timely manner. The hearing will be conducted in accordance with Due Process Administrative Procedures Act. Commission will render a decision within the time frame. That's the one we publish in the weekly reports. It's also at the Real Estate Commission website. Maintain a public docket so you can attend these meetings. You can attend these hearings if you like and sit in the audience and listen to them. You can licensees can voluntarily surrender their license. You'll see the consent orders a lot of times for these things. They'll say, "Hey, I basically plead guilty, take my license back." So sometimes you'll see those in the orders. And they can write up disciplinary action. Those are the orders that we post. Talks about the penalty is fine not less than $500 and not more than $5,000 for each violation. Again, you can voluntarily enter a consent order in lieu of a hearing. And then they put annually the department's going to post the number of complaints, investigations, the length of time. If they take their license, you got to wait 3 years for seeking relicensure. You got to show that you present evidence that you're now trustworthy and have a good reputation. Complete the education, any other requirements. And it talks about no cause of action may arise against the owner of real estate or licensed real estate agent of a party to a transaction for failure to disclose in the transaction. The subject was this kind of your psychologically stigmatized property. Somebody is in there and they commit suicide or they die of some sort of disease or virus. Any off-site condition that does not directly impact the property being transferred. Any psychological impact has no material impact on the physical condition of the property. Nothing precludes an action against the owner of real estate or the licensee for intentional misrepresentation. So do not lie to people. If you don't want the answer, you can be diplomatic. Hey, that's a great question. Let me write that down and get an answer from you from the seller or from some sort of expert. And then it talks about they're going to publish their standards relevant to the approval and conduct of education. Basically, the LR is going to regulate educators. And this is basically education. They can discipline educators that are not doing what they're supposed to be doing. So that's for the educators more than you guys. And that's the end. So you can see it's a huge change. It took us 2 hours to go through all this stuff. So I recommend you read this on your own. Watch this webinar a couple times. We've got 3 other webinars from the lobbyist and from me and Austin on here. Review this webinar. And so what you want to do is read the new forms. Remember, we got new year, new laws, new forms. So read these forms. Send any comments to me and Austin.
We have a few questions.
Yeah, Austin's got some questions. We'll cover those. Read the new license law and attend training at your local board. Attend SCR training. Attend LLR training. And we'll get into the questions.
Does the same law for escrow funds that you described count if you have a closing attorney who's doing all the escrow accounts? Does he
That's a great question, Austin. Related question. What if a lawyer's holding the earnest money? So a lot of brokerages have said, hey, interpleader, mediation, handling earnest money disputes, it's more trouble than it's worth. I'm going to get an attorney. I'm going to take the buyer. When the buyer wants to write that $500 check, that $1,000 check, that $5,000 check, I'm going to take them to the lawyer's office. The lawyer's going to take the check. The lawyer's going to hopefully have an escrow agreement that the buyer and seller sign that says how the money's deposited, how the money comes out of deposit. And since the broker didn't receive the money, the law firm received the money, none of these laws apply to you brokers. So you basically can wash your hands. Now, be careful if lawyers are doing this to get closing referrals, some rest-based issues attached. But I know a lot of brokers often use lawyers to hold earnest money to get away from these earnest money disputes. Earnest money disputes probably the #1 call that we get. And one of the reasons the Forms Committee added contractual disbursement of earnest money back in 2012.
We also had questions about how does continuing ed work if South Carolina is your secondary license state? So
Right.
say your primary is in North Carolina, how does that work?
Right, that's another good question. So say, it depends where you live. So residency is going to be critical. I was at Charleston when they got a ref grant. They videotaped Rod Atkinson's presentation and Diana Brothers' presentation. Those should be available on the internet at some point. But Rod Atkinson, it's key where you live. So LLR is going exactly by what the legislators put into law. So if you're a resident of South Carolina, you do South Carolina CE. So if you've got a North Carolina license and a South Carolina license, it doesn't matter which one's primary. You live in South Carolina, you do your South Carolina CE. If you live in North Carolina, so you say you live in Charlotte, even though you practice maybe down in Rock Hill, Fort Mill a lot, you do your CE, you live in North Carolina, you do your CE in North Carolina. The Real Estate Commission in South Carolina looks at the law and says you're a resident of North Carolina, you're good to go with your CE.
Does the 25-year CE exception, is that for only you've had to practice in South Carolina for 25 years, or you could have practiced in any other state for 25 years?
So the question is about this 25 years. Like I said, you want to get these answers on license law directly from the Real Estate Commission. Just reading the plain language in the statute, it says 25 years of licensure. So in South Carolina, when they talk about licensure, they're talking about South Carolina licensure. So I would assume you have 25 years of South Carolina licensure. But again, the Real Estate Commission is the one that gives the license and gives the exemption. So get that answer direct from the Real Estate Commission. Their phone number is 803-896-4400, and you can ask to speak to Rod Atkins.
We also had someone ask in regards to transactional brokerage. If the agency does not have the listing agreement, can the transaction broker agreement be used, or must the buyer have a buyer brokerage engagement?
So the question is about transactional brokerage where you don't have a listing?
Yes.
So say I'm an associated licensee of a broker in charge. I work for Nick Terminus, broker in charge, and we don't have the listing. I've got a buyer in my car that wants to buy the listing. So I've got a couple options. So obviously I could sign a buyer agency agreement with this buyer, and then the buyer could either pay me, or if it's in MLS, or I've got a compensation agreement with the for sale by owner, or it's in MLS, or I've got a compensation agreement with a listing agent, say I'm outside of my MLS area. Our brokerage is not a participant in that MLS. I've got a compensation agreement. So if I got a buyer client, right now that's legal. That's how I get to closing. In January, you've got more options. So say I go to that buyer and say, I've got to have a buyer agency agreement. The buyer says, I'm not signing that buyer agency agreement. I could actually say, well, would you sign this transaction brokerage agreement, or would you be a customer? And both of those in 2017, you could take it to closing, and then the listing brokerage could pay you the cooperative compensation in the MLS, or if you're not an MLS participant in the compensation agreement, that two brokerages sign before presenting the offer, or it's for sale by owner, the compensation agreement the seller is signed before sending the offer. That's it. I know it's long. This is designed for going back and reviewing, but remember, new year, new laws, new forms. Read all these forms. Contact me in Austin. There's a phone number here, 772 772-5206 with any comments. Contact your local board, find out when instructors are teaching there, find out if SCR is coming in the van, on the van tour. Watch this webinar again and again. Come to any training. The SCR will have training. Rod Atkins is going to do a webinar in November, probably November 17th. Don't hold me to that. We're scheduling some classes between now and January. I think Diana Brothers is going to teach a class for us. Got a tentative date, but stay tuned for that, your weekly updates. Check with your local board. A lot of the local boards are hiring instructors to teach locally, and if SCR is in your area, we may be teaching there as well. So check with your local board. Keep following the weekly update for classes. Mike, you got anything? Thanks to Mike Kress for doing the webinar tech stuff as always. Thanks to Austin Smallwood for monitoring the Real Estate Commission, talking about those forms, and thank you for listening.